Hello and welcome to Delhi Law Firm. Today we are discussing a very important Supreme Court decision that directly affects ordinary citizens, professionals, business persons, and anyone facing criminal proceedings who is worried about passport renewal. Many people believe that if a criminal case is pending, their passport can never be renewed. This conversation explains why that belief is legally incorrect.
Absolutely. This case clarifies the balance between individual liberty and judicial control. The Supreme Court made it clear that merely because criminal proceedings are pending, a person does not automatically lose the right to hold or renew a passport.
Let us first understand the background. The appellant was an Indian citizen whose passport was valid for 10 years and expired in 2023. During this period, certain criminal cases were pending against him before different courts. Importantly, he was on bail and fully cooperating with the judicial process.
In those criminal proceedings, the courts had imposed conditions. One key condition was that he could not leave India without prior permission of the court. His passport had also been deposited with the court to ensure compliance.
As the passport was about to expire, the appellant approached the trial court and sought permission to renew it. The court allowed the passport to be released strictly for the purpose of renewal and directed that it be redeposited after renewal.
Later, another High Court dealing with a connected criminal appeal also clearly stated that there was no reason to deny renewal of the passport for the regular 10-year period while continuing the restriction on foreign travel without court permission.
Despite clear judicial permissions, the Passport Authority refused to renew the passport. Their argument was based on Section 6, subsection 2F of the Passports Act, which refers to pending criminal proceedings.
This is where the legal misunderstanding began. The Passport Authority treated Section 6, subsection 2F as an absolute prohibition, ignoring the statutory exemptions and the judicial safeguards already in place.
The Supreme Court examined the entire statutory framework of the Passports Act, including Sections 5, 6, 7, 8, 10, and 22, along with the 1993 exemption notification known as GSR 570E.
The court explained that Section 6, subsection 2F is not absolute. It is expressly subject to other provisions of the Act, including Section 22, which empowers the central government to grant exemptions.
Under GSR 570E, persons facing criminal proceedings are permitted to obtain or renew passports if the concerned criminal court grants permission and imposes appropriate conditions.
The court emphasized that criminal courts have the authority to supervise travel. They may allow passport renewal while still requiring prior permission for every instance of foreign travel.
A crucial clarification made by the Supreme Court was the distinction between possessing a passport and actually leaving the country. A passport is merely an identity and travel document. It does not grant automatic permission to leave the country.
The authority to allow or deny foreign travel always remains with the criminal court. Therefore, denying passport renewal on speculative fear amounts to undermining judicial supervision.
The Supreme Court also addressed the constitutional dimension. It reiterated that the right to hold a passport and the right to travel abroad are part of personal liberty under Article 21 of the Constitution.
Any restriction on this liberty must be fair, just, reasonable, and proportionate. An indefinite denial of passport renewal, despite court permissions, fails this constitutional test.
Another important aspect discussed was conviction versus trial. The court clarified that a person who has been convicted but whose appeal is pending stands on a different footing from someone merely facing trial.
In this case, even after considering the conviction and pending appeal, the High Court had permitted passport renewal. The Passport Authority could not override that judicial assessment.
The Supreme Court criticized the approach of treating passport renewal as impossible unless the court simultaneously grants permission for a specific foreign trip.
The law does not require courts to pre-approve future travel plans. Courts may retain control by requiring permission each time travel is proposed.
The court further clarified that even if the exemption notification is applied conservatively, the maximum consequence would be issuance of a short-term passport, not complete refusal.
Therefore, denying renewal altogether was legally incorrect and administratively excessive.
In conclusion, the Supreme Court held that once criminal courts consciously permit passport renewal and impose safeguards, the passport authority must respect those judicial directions.
The appeal was allowed, previous refusals were set aside, and directions were issued to reissue the passport for 10 years, subject to existing and future court orders.
This decision sends a strong message that constitutional liberty cannot be curtailed through rigid administrative interpretation.
It also reassures citizens that cooperation with courts and compliance with conditions protects their fundamental rights.
If you or your family members are facing issues related to passport renewal, criminal cases, bail conditions, or constitutional rights, correct legal guidance is essential.
Delhi law firm provides legal assistance across India in matters involving passports, criminal law, constitutional remedies, and court permissions.
For detailed guidance and professional support, visit dellylawfirm.news.
Remember, law exists to protect liberty through reason, balance, and judicial oversight, not to impose lifelong restrictions without justification.